Good evening, everybody.
Good evening.
All right, it's almost time for us to be finished. All right, so I'm going to move right in. This evening we're going to get in a little bit about refreshing our memory on the the negotiating, and then pull in some drafting the deal. We're going to practice that one more time. So let's talk about negotiation. And these are just some review slides from last week, because now we're going to start to, I guess you all are going to do the negotiations on this employment contract. And I just can't wait to see how it's going to turn out, because you got to negotiate now. Okay, you got to defend your client. That's what I'm looking for. And so one of the things that we have to be mindful of is that, the most important word in this whole thing is risk. And it's a word that has just really gotten away from a lot of you all this semester. It's like you're just writing an agreement just for the sake of writing it. But no, you have to be looking for risk issues related to your client. That's what you really have to be working on at this point, beginning now, when you start to do your negotiation with the other side. Again, a deep understanding of the client's interests. I saw some things when I looked at the deal memos that you all did, which if I were you, okay, you're going to do another draft now, okay? After, don't just assume that it will just be based on your negotiations. Okay, any learning or any ideas that you pick up that you think is going to make your draft better, you need to be trying to incorporate that in there. And those deal memos were, they were not like making me sing glory hallelujah. They were just like bullet points here and there, like a case brief, like the case briefs that I saw. And that's not going to be able to get you what you need. What I'm saying to you, you're synthesizing your information from the transaction materials to synthesize it down all in one place. You want it to be something that you can use, that you don't have to keep going back to the transaction materials. But I'm going to talk to you tonight about my game plan and what I do to kind of organize mine. I call it a deal memo, but it's something it's a cheat sheet. And that's what I want you to get in the habit of being able to have. Keep in mind that, the partner may read it as well, so you don't want to write it just for your own consumption. You see what I'm saying? And you want to keep in mind that you also want to, when you have bullet points down there, what I'm finding is that people are inferring their own meaning into the actual fact of the thing that they read. They put something here that really does not mean that same thing as what they read from the transaction materials. And so they're making assumptions about information that may or may not be necessarily true. And that comes from shorthand type of bullet points that are not on point with the actual fact that was provided in the transaction materials. And so you also want to just be mindful of the cooperation that you want to have. I'm sure, we're going to have that in this particular setting. But sometimes it can get very heated. You can be dealing with a very tense issue. And so you want to keep that in mind, because that's the only way that you're going to be able to really get the best outcome. If you have blood in the water from the beginning, if there's bad blood between the parties, it's not going to settle. So it does not do any good for the client for that to be the case. And so I want to remind you about your worksheet. You want to make sure that you are, that you have your worksheet together, that you're going to have in mind when you get ready to do the negotiations. And what I also want to tell you about this worksheet is that it also, is a helpful aid, in the place of a deal memo. I don't want to say completely in the place of, because I really want y'all to get into getting those deal memos done. But this is also going to keep you on task with your goals. What is that problem that you want to solve? So it'll be very helpful as well. And then I want to direct your attention back to some slides from the beginning. This is really from the beginning. How to think about writing a contract. Okay? Look at that. What are the client's goals? How can the contract frustrate or further the client's goals? What? Risk. None of this is being incorporated. It's like we have forgotten about this. These are the things that we have to focus on in this entire transaction, in doing these transactions. Problem solving, resolving problems. That's what this is all about. And as I could tell you, I could give you the answer, but that's not going to help you. When you get your own client, you're going to remember this, and you're going to say, "Oh, I'm glad I took these classes," because it's going to be like you're going to be out in the cold, and you're going to be like, "Well, okay, what? It's going to be up to you to be able to make the decisions and to do the problem solving for the client." And so you want to be able, to have some practice, and you want to be able to develop that skill. Risk, all throughout these slides. And then remember this. Risk. We have to develop that skill of being able to, identify issues of client concern, money issues, risk issues. We talked about all this. That is the thing that is paramount in what we should be doing, what we should be focusing on in the negotiation, in the drafting of the contract. That is the basics, the bedrock of the agreement that I showed you last week from the problem. It was all about controlling risk. And so we're going to look at that Bill Cosby problem tonight and try to see if we can pull some of these things together. But what I want to remind you of the different types of negotiating styles. The one that I was telling you about is the one that I find that's going to get the most bang for the buck. Most of the time, it's going to be that interest-based negotiation style, where the parties focus on finding interest of each one of the parties. And then you want to focus on the interests of the parties. And then what I wanted to remind you of also is that you want to be concrete about your issue, okay? Whatever it is, there's going to be your you're going to have a zero tolerance for something like that. And you can't move on it. In my perspective, when I go back and we look at the negotiation worksheet for this problem, I'm clear that there should not be an occurrence where Bill Cosby ever utters a word. Okay? And I am clear that one of the interest, high interest, is going to be keeping information confidential. Okay? And so you may see some discussion about what may or may not be ethical for lawyers to do. It's not ethical, or it may not be ethical to impede a law enforcement investigation. And I'll just say, okay, I'm going to be flexible with you, Andrea. I'm not asking you to do that. All I'm saying to you is, if you disclose information, then you will be in breach of the contract. So however you want to make it, fix it in your mind, that's fine. But whoever it is that you disclose information to, that's going to be written into. So it seems to me that it may have been one of those issues that kind of slipped by, because on the one side, somebody may have gotten too flexible. They were not really concrete on their interest on who information could be disclosed to. And so that's how you get people sending information now to the DA, where there's a confidentiality agreement in place, but somehow people are leaking out information that's supposed to be confidential. So these are things that need to be, it's risk that needs to be controlled in the negotiation and in the agreement. And so you all may be meeting by telephone, you may be meeting by email at some point this evening, some way, somehow, try to transfer your information from you to co-counsel so that you can get those negotiations started. And then these are things that you just want to keep in mind. You want to be prepared. You want to prepare in writing. You want to understand your client's interests again. And they talk about getting authority. That means authority to settle. Let's say it may be an amount of money, or it may be a particular issue of concern that the party may not want to do this thing, or they may want to do this thing, and that you would need to get authority from the client before you are able to say, yes, that's okay, we can settle for that. And then again, I want to talk to you about those sections of the agreement that we're working on with our transactions. And so, as always, we want to go in and we're going to set up the format. That way, once I have it set up, I can go in and put my pieces in. I already know that my numbers should be correct here. 1, 2, 3, 4. That way, when you turn in your final draft, you don't have 12 here and 9 here and all of these different kinds of things. You want to go ahead and set it up and then drop your information in there for use when you're going along. And so we have our packet of information. So I'm showing you how I go about doing it, to get ready to draft my deal memo. I start looking at it, and I can see it when I'm looking at it. I'm like, okay, that's risk. Okay, this is going to go there. I start to highlight and synthesize our information that I'm going to take out of this to put onto my one document so that I don't have to come back to this large piece of information again. But I'm seeing things throughout there already that I can see already. Okay, no, I need to control that. That's risk, that's risk, that's risk. All throughout that packet of information. Here, they talk about, okay, the press release, however, never mentions the Fifth Amendment. Okay, so that's something that I need to work on. That's risk. And it does not contain a promise that the defendant would never be arrested. In fact, it says to the contrary, which I don't really agree with what her meaning of that sentence is. But as you can see, I am starting to go through my information to be able to pull out the information that may or may not be relevant. All of this is not going to be relevant. So I need to try to synthesize it down to some place where I can work from this information. Then I'm going to synthesize this down even more. That is what you have to do. That's how you learn. You get a deep understanding of the client's interests. You can't do it just by trying to grapple with this large piece of information and keep thinking that you can go back to it and find what you need, because we're missing relevant facts. But once I do it this way, this is just my way. I'm not telling, everybody has their own way of doing whatever it is they need to do. But you have to have some type of a process for synthesizing all of the information that you have. But then I'm able to see at some point here that I have two large issues that I really need to be concerned with. I need to be concerned with the criminal charges that are currently pending, making sure those criminal charges are completely released. But then there's also an immunity issue. There's no way that, based on how voluminous this information is, that I will be able to really key in on that without synthesizing this information down. And then we get here the police report. This is, see, I see information now. I know I'm going to have the parties and names, so I'm starting saying, okay, that's going to go in the preamble. I am starting to map out the document, the information, and that is how I go about synthesizing the information down to something that I can put into my deal memo now, something that I can use to do my negotiation and drafting of the agreement. And then I also have my worksheet that has very useful information, because when the time comes, this will be information that I can use also in the negotiations and in the drafting of the agreement. Okay, so once you get that information synthesized, then we're starting to work on writing the memo. Let's just say that you have, gotten through your negotiations and the other side has given you some points, or you have some points that you still want to work out, and you're working on that first draft. And so the first thing that you would do would be to start to draft the memo, draft the agreement. And you want to start working on that on your introductory provisions. I am just doing this so that we can practice the thinking through the negotiation and making sure that you're clear on some of the things that we're needing more work on when we're drafting those agreements. And so now we're starting to work on those in the introductory provisions. And so what are we going to need for that? Yes, ma'am.
The parties' names and identifying things about the parties to distinguish them.
Yes. And so we call that what? And then what do we do after the preamble? Yes. And then what? Yes, ma'am.
Words of agreement.
Words of agreement. So it should be just that way, just to get you started in your mind on how to get started with that agreement. And surely we have this part down at this point. But if we're going to start with those introductory provisions, we're going to start with the preamble. What are we going to need then for that? The names of parties, yes. The name of the agreement and the date. And so we are going to want to be clear on this information. We usually, hopefully, are going to be getting it from our transaction materials. And so that is how, and that is why, to me, it is important for you to synthesize most of the information in one place so that it's easier for you to be able to go to this place, this reliable place that has the specific information and not so much so just like bullet pointed information, because then you're going to be unsure about it, and then you're going to end up doing what? Going back to the transaction material, which defeats the whole purpose. And so you're going to want to look in your deal memo for your materials. Okay, so now what does our transaction information say about the date? If anybody.
Transaction 3.
Okay, so we're working on the Cosby.
Oh.
And so just keep in mind, we're looking for the date. We're looking for the parties. And so for the parties, we want to identify the parties, and then after that, we're going to define the parties. Remember now, we're dealing with named parties like we were in that Stormy Daniels deal. And so for those types of parties, we want to make sure that we identify them in some kind of way that we are clear that we have the right person. It may be a date of birth, it may be a driver's license number or social or something like that. But that's the type of information that we would be using to identify a party individual party, because at some point the person does not keep up their end of the agreement, and you need to file some type of a lawsuit against them, or there is some type of a remedy that needs to be had. You need to have the right person. You need to have a person who can bind the agreement. But then when I'm looking for information about the parties on that police report, all of Bill Cosby's identifying information is right there. Now, there will be some digging that would have to be done to find Andrea Constand, but in your in your transaction materials, you will normally have some information like that. But what I'm saying is that you will go through and you highlight that information, you synthesize out the pieces that you need to be able to draft the agreement. And so you take all of your pieces out that you need. It really is, in many respects, it's like a puzzle. So you don't need all of the thing, but the pieces that you need to be clear on those, the information or the facts that are coming out of those particular parts. And then you want to, after you identify the parties, then we are going to define the parties. Sometimes, you like to use seller or buyer. In a situation like this, you will be able to do that. I just use Constand and Cosby. And then, obviously, for me, I want the agreement name to encapsulate everything that it is. The mutual release of the civil suit and settlement agreement and confidentiality agreement. And so that is what I am going to name it. And then, again, for individual parties, I want to have some type of date of birth, or this is just an example. I don't know what her information is. And William Henry Cosby, I'm sure that I'm getting that straight from the transaction materials. Pennsylvania driver's license number is right there. A resident of Pennsylvania, Cosby. So if anything were to happen in the future, I know that this is the individual, this is the Bill Cosby that I'm looking for to bind the agreement, and in the event that there is some mishap or some breach, he doesn't pay the settlement, I'm able to go after the right person. And so then I just put that right into the place where it goes. And so what I'm saying to you all is that it's the same thing every single time for every type of agreement. Once you get the hang of this, then you can, all the different little sections that you want. Once you realize what each section does and the purpose of it, whatever name you want to give it, however you you want to put things here or there, but we have to really get the basics down, and we're still working on getting those basics down at this point. Okay, now we have that preamble. Now we need to move on to the recitals and the words of agreement. And so as we go on, you're always synthesizing and resynthesizing the information to make sure that you have a deep understanding of the client's goals. Obviously, there will be each deal is going to dictate the amount of recitals that you would need. But what I am trying to do is I am trying to understand that this is the only way that I can understand what understanding you have of the deal. And so and not only that, but it's clear to me that there is an inability to spot those issues, because even if it's missed in the recitals, it's not communicated in any other places throughout the agreement. So I am asking you to lay the foundation in your recitals to help you to understand what's going on in the deal. Yes, ma'am.
Are the recitals something that are also negotiated or redlined in the contract?
Oh yeah. You're gonna get recitals. Somebody's gonna say something in the recital. It might not happen here, but in the practice of law, somebody's gonna say something in the recital that you don't want said in the recitals, and especially in the confidentiality agreement. And so it depends on who's drafting the agreement. But you draft it, and then the other side will say, no, we don't want to say that, or we want to say this. So yes, it's all negotiated. Yes. And then the words of agreement again, a recitation of the consideration and a statement. It's a two-part thing. So, you really want to have both parts of that for the words of agreement. And the reason that I am saying to you, it's a good idea to not just brush past that, because it is going to help you when it's time for you to start working on your action section and that subject matter performance provision, especially when you have worked on one section, and let's say some people, I'm almost sure, don't go straight from this section to their definitions. They may stop here, and if you come back a few days later, you can't remember, okay, now who? This will help you to go straight into that action section and start working on the subject matter performance provision. It's a good place. It just lays the foundation for you to be able to communicate those two promises that you need in that subject matter performance provision. But what you want to do is you want to lay the foundation. Now, there will be some things that you don't think you need, but when you get to a certain point and you start talking about a certain thing, then you'll ask yourself, somebody will ask, okay, who is that? What is that? So you have to kind of lay the foundation and tell the story so that one thing comes from another. You just can't start talking about Bill Cosby or Constand. You want to kind of introduce the person, say who they are, and then straight from the transaction information, you'll see that how their relationship starts. That will be needed in an agreement like this, okay? Because, we can see, or, some people probably still think it's a good idea to do it, but a side letter agreement, you need to lay it out so that people will know the purpose of the agreement. and what risk it is that you're trying to control. This is a hush agreement. We're trying to keep our mouth closed about something. And so you have to go to the water's edge at least to talk about what it was. And so this lays the foundation. It talks about how they met, and then, their first encounter. And then it talks about the occasions, the different occasions that they met. Now, if I am negotiating with the other side, I'm putting this in here because I want it to be clear. Me personally, it's important for me for it to be clear that she went over there 5 or 7 times in his house. What the hell did she think was going to happen? That's what I'm thinking in my mind. Okay? But then the other side is going to say, they probably going to say, okay, we don't need that. And so that's going to be an issue of contention right there. Right there in the recitals. Even though these recitals don't really bind anything, I feel like I need to lay the foundation so that it's clear what I am going to be asking her to do in the end, and whatever it is that she's going to be asking me to do in the end. You just can't start by saying, okay, Bill Cosby and Constand, now we're going to have the agreement and the end. You have to lay the foundation to talk about it. Is there? No. Okay. And so then it is going to be critical. Some people, obviously it may not occur to them that, so many facts will be needed. But we can't, at some point, some of these people, you're going to have representations and warranties about who else information can be disclosed to. But you got to talk about who information has already been disclosed to. And so you have to lay the foundation of who all she has already told and who has been reported to. At some point, we're going to want the Montgomery County District Attorney to release his charges, and we just can't start talking about him without just talking about how he got involved. And so all of those facts, you have to lay the foundation that would be relevant, because he's going to be a relevant player at some point in the agreement. Okay, and so then in my words of agreement, for me, in an agreement like this, I want to go ahead and just say what this agreement is about. Eventually, it's going to dovetail me into my subject matter performance provision, but when I get there, I won't be stuck. It's going to be a mutual release and settlement and confidentiality agreement, which will provide for Constand's promise to assist Castor in obtaining the Cosby immunity, to refrain from initiating any further criminal proceedings in any criminal court against Cosby, to refrain from disclosing any events surrounding the alleged incident, and to dismiss the pending civil suit in exchange for Cosby's promise to pay the financial consideration. Now, if I close this out and say, okay, I'm going to come back to this in a day or so, and let's say I say, all right, I already know I have my 4 definitions that I need to put in here, and I have a few others that I'm going to work on. I'm going to go straight to my section 3 and start working on that. I can pick up right here and start working on my subject matter performance provision. And so then after our section section 1. Then we move into our section 2, which is our definitions. And I'm not going to spend a lot of time on definitions, but what I would say is we definitely want to start by defining the agreement that is going to be drafted. So that's boom. The first four, I already know what they are. Then I'm going to define the parties. And then I'm going to define the subject matter of the agreement. I'm not going to fill in a whole lot of the definitions here, but I have four, boom, 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 that I know I need. The subject matter of this agreement, the whole reason of this agreement is a settlement agreement. We're settling, we're releasing the civil suit. So then I need to define the March 8, 2005 civil suit. The alleged incident, that's going to be critical. Caster, I need to define him because he's going to be a critical player. As you will see, the things that are important, the client issues, the issues of client concern, releasing the civil suit, the confidentiality, the pending criminal suit, future criminal suits, immunity. These are my risk issues. The whole thing is going to be about controlling risk. And that's what our agreement should be about. And so after those definitions, then we're going straight to what now? Yes, ma'am.
Business action section.
Our business action sections, and we're starting straight away with our
Subject matter performance.
okay, and which is in the
Actions.
actions portion. Yes. And you've already given me my first section. What is my next one after that?
Purchase price.
Or
Payment.
provisions. Subject matter performance provision, then my payment provisions. These are words that are just in my brain. I don't have to go anywhere. I do not have to look on a piece of paper. It's right there in my head. I walk around with it. Somebody asks me, I could be walking down the street. Somebody say, okay, what are the first two provisions in your subject matter performance, not action section, your subject matter performance provision and your payment provision? I know that's where I'm going to start there. And then not only that, but I know I'm going to start with my subject matter performance provision, and then I'm going to go to my cheat sheet, which is my words of agreement, because I already have it saved there for me. I'm going to say, okay, let me go back and refresh my memory on the promises that are supposed to be encapsulated in this agreement. That is the reason that I want you all to kind of build those up in your words of agreement, just a little bit there to reflect the exchange of the consideration and then the magic words after that. And so again, it is the promise to perform. It is the main subject matter of the contract. And then for each party, you need to have a promise. And there are two types per each one that you can have. And you just need to make sure that you are reflecting the right kinds of promises in those agreements that you're. Some agreements are, not all agreements, are going to be the type where you can have a reciprocal type of a promise. The promise, it comes from the signing of the agreement, so to speak. But you have to have one reflected per each one. And so here, it is not like the stove agreement, so much so from Constand's perspective, her promise in this transaction is going to be more like the one from the licensing agreement. By signing this agreement, she promises to assist Castor in obtaining the Cosby immunity order, to refrain from initiating any further criminal proceedings whatsoever in any criminal court against Cosby, to refrain from disclosing any event surrounding the alleged incident, and to dismiss the March 8, 2005 civil suit. And Cosby shall provide financial consideration by paying to Constand the settlement amount. You want to kind of be, you don't want to be so casual about this particular provision, because a lot of things flow off of this provision. Conditions, or whether they are a walk away or not, flow off of whether or not it is, or can, off of whether or not it's a subject matter performance. And so your conditions to closing, they trigger off of your subject matter performance provision. So I would just want you to be more mindful of making sure that the promises from each one to the other is encapsulated here, so that a person does not think that they have any wiggle room in the event of any type of a breach scenario. And so after the subject matter performance provision, then we go straight into our payment provisions, whatever they may be for the particular deal. We had, a little bit of reading on financial provisions, but there was not much from that that is necessarily applicable. And there were a lot of contradictory information in there. I am going to tell you, throughout the practice of law, there will be times where you will have to reflect numbers throughout an agreement, and you want to be uniform. And most prominently, we usually reflect money with 2 decimal places, and your text is telling you not to do that. And so I am telling you that in litigation, or out of litigation, or just transactional law, whatever the case would be, there will be situations where somewhere in the agreement you will have to reflect a fractional amount, and it's going to be difficult for you to do it without 2 decimal places, and then in other places you're reflecting money with no decimal places. The uniform thing to do in every place that I've ever seen is to reflect nominal figures with 2 decimal places. And so I see that some people still don't really like that. I'm not too, I may make a comment about it in some of your work, but if I can see that it's just something that you like to do, it's just a style thing, then it's up to you, but you will see that it will get to be kind of, it's not going to be uniform in some places, because at some point you may need to reflect something with 2 decimal places, because there are some other figures after that to specifically reflect that thing. You need to have 2 decimal places, and so it just makes it easier and uniform throughout the document to do that. And so where your payment provisions, though, we want to be sure that we are doing those the same way all the time. Some people may want to do it all in one provision, one covenant, or as a declaration covenant combo. But at any rate, if it calls for it, you want to be answering that question of payment of what, to whom, when, and how. And then we know what the settlement amount is. Here is reflected in the deal, in the transaction materials that we have there. But then these are those remaining action sections. And not all agreements are going to have all of them. Some may have some may have one, some may have none. For this type of agreement, there is not going to be any term. It's not an agreement that is requiring anything to be done like in 2 years, or the agreement will have a term of 2 years or a year. There's not necessarily a closing date or closing deliveries for this type of agreement. And so then you'll go straight into your business provisions of that business action section. But these are the subject matter performance provision, and then our settlement amount, $3.4 million, and then the payment of the settlement amount. It talks about what Cosby shall pay the settlement amount to Constand in the form of certified funds, and then it tells you when, it tells you how. Okay. The settlement amount, $3.4 million, and then it tells you how and when. Okay. After she has completed all of her covenant obligations set forth here in this 3.2, 3.21, 3.22, there's certain reasons for wanting to do that. And then which shall then not be negotiated until after she has completed all of her covenant obligations as set forth at 3.6 and 3.61. And then the certification of payment of the settlement amount. Since I'm not going to necessarily have those closing deliveries, I'll go ahead and say here that it's going to be attached as Exhibit A. Once all of that is finally completed. And so then those would then be the starting of those business provisions here. This is kicking kicking it all into action, actually, the business provisions. And so it's I don't have to, there's a lot of struggling here about what's relevant and what's not relevant, but now I have a fix on my client issues of concern. And so it's going to be the same thing throughout the agreement, a focus on that. This is what I'm concerned about, the criminal complaint. And so that's going to be one of my first action provisions. As a basis of her acceptance of the settlement amount, she shall withdraw any and all criminal complaints made to any law enforcement agency, prosecutor, or district attorney in any state in the United States or any state outside of the United States pertaining to the alleged incident. See, I have that alleged incident. I will be able to go back into my definitions and solidify that to make it clear on what we're talking about when we talk about the alleged incident or any other incident involving Constand and Cosby. I am needing to control that risk in any way, shape, or form, any way that I can. Also, in the furtherance of this obligation, this particular obligation, Constand shall file a written declaration or affidavit. I'm defining it now. Withdrawal declarations. These are declarations that will have to do with withdrawal of any criminal complaints. So she's gone out there now, she's filed a complaint with the police department in Canada. Then they forwarded it to the police department here. So anybody, la-di-da-di, everybody knows about this thing. So I need to control that. Okay? The district attorney, she has one out there. So I need her to make a clear clarion call out to everybody. Whatever she said I did, I'm withdrawing it. So nobody can now say that, you know, that she didn't do it or this or that, or I won't. This is a requirement of this agreement. The obligation set forth in this article shall not be completed until each and every withdrawal declaration specified herein has been filed with that respective agency by, and I'm saying how that should be done. And a copy via certified mail, and a copy including the certified mail tracking numbers delivered to Cosby pursuant to the notice provision, which we're going to find later on in the general provision section of the agreement. Also, in the furtherance of this obligation, Constand shall agree to cooperate with efforts to amend Castor's February 17, 2005 press release. See, I've gone through my transaction materials and I have highlighted all of my risk areas. Now I'm going to come through in my business section now. I've got my actions out of the way. I'm going to come through in my business provisions and I'm going to set out all of the covenants that I need to do that will help me to control that risk in the business section of the agreement. Since, you know, now looking back in hindsight, but hopefully you will be able to look going forward when you see certain situations that you should be able to see, first of all, obviously, Castor wrote the press release based on the parties' agreement anyway. There was some wiggle room in there. So now I'm looking in hindsight. I'm just writing a better agreement. And not letting some of these things just be verbal things. But now his press release was lacking in some areas. So we're wanting whatever Constand needs to do to cooperate with those efforts, which may be her, by, you know, letting him know that she's in agreement, or whatever it is that he would need her to do to further his efforts in to amend that press release to make it clear that the decision not to bring charges against Cosby means that the Montgomery County District Attorney's Office will not bring charges against Cosby now or in the future. And that the decisions shall bind the Montgomery County District Attorney's Office in perpetuity. And then you want to make sure that the procedure for carrying out this obligation is clear. This obligation sets forth in this article shall not be completed until a copy of the amended press release is delivered. See, I need to have my whole book completed before I release the settlement payment. And then refrain from initiating criminal proceedings against Cosby. So there, I can see that there will be some issues of negotiation here. At first, when I'm drafting this, I'm saying to myself, as a basis of Constand's acceptance of this settlement amount, Constand shall not, from the date of signing this agreement until forevermore in the future, initiate any criminal complaints. See, this is why Cosby's in jail right now. Or be the complaining, okay, I'm going to change this word. I guess I would say witness, but I'll change this and just say victim. Because her attorney's thing is going to be, oh, but it would be unethical to not cooperate with law enforcement with the criminal investigation. Okay, witness, whatever you want to call it. All I'm saying is she cannot be a witness if she's not a victim. Or be the complaining victim in any. See, that the DA does not just file a criminal complaint. They're doing that because she has authorized them to do so. She has gotten $3.4 million, kept the money, then double back around and still file a criminal complaint on the same event. That's unheard of. Now that I'm saying it in here, it's just really, it's boggling my mind that it happened. So I want to make it clear, in any court, in any criminal proceeding, here, now, or forevermore, in the United States, outside of the United States, wherever it may be. Okay. So that's my one concern. My other concern is the immunity. If I can get it, I want it. I'm not letting her know that I don't have, at the point of these negotiations. But if I can get the immunity, I want the immunity, because anything that I may have already said, or I want the full immunity if I can get it, to clear up that risk area. I am, again, controlling that risk. This is an issue of client concern here. So also, as a basis of her acceptance of the settlement amount, she, Constand shall agree that Castor, first, she has to agree with him that he should draft and file the immunity petition, and assist him in drafting and filing the immunity petition, which may require her to file some type of a declaration or supporting document. Whatever that may be, I want her to agree to assist in that effort. That shall culminate in the Cosby Immunity Court Order, signed by the presiding judge of a designated court pursuant to the Immunity Statute. There's an immunity statute that's talked about there. That's going to be, I'm going to place that in my declarations or in my definitions. I want to make sure that I sneak that word in, Fifth Amendment, because there's much said about the fact that the word Fifth Amendment is not even mentioned in the press release. And so then I'm laying out the procedure here for complying with this particular obligation, the furtherance of this obligation, she shall submit to Castor any written declarations, affidavits, whatever. And the obligation set forth in this article shall not be completed until each and every immunity declaration requested by Castor has been submitted to Castor. The Cosby Immunity Court order has been signed by the presiding judge of the designated court, and a copy has been received. In addition, we want to clear up that press release issue where it specifically talks about the fact that there was the fact that there is no mention of immunity in the press release. So I am just showing you how to go through and to be clear on what those issues of client concern are. Where did I get all this from? From that first paragraph right before the actual words of agreement, the two parts, the first part, all of this came from there. So you have to lay that foundation. Once I laid that foundation, then I come into my subject matter performance provision and I clarify that there. And then now I'm just drawing off of that subject matter performance provision as I go. I go back up, I say, okay, what's missing? Okay, so now I need the confidentiality. That's an issue of concern. I need the dismissal of the civil suit. And I'm showing the procedure for each one of them. I make it clear that this is a basis for her acceptance of the settlement amount. And then I lay out the procedure for the obligation set forth in this article shall not be completed until the presiding judge signs and enters an order dismissing that March 8, 2005 civil suit with prejudice, and a copy is delivered to Cosby. And then all of these will be, attachments to the agreement. So that's business. And then representations and warranties. And again, I'm just coming back from some old slides just to refresh your memory. If a breach of a representation and warranty is discovered after the agreement is signed, the agreement may provide for remedies. It kind of all flows together. And so then, in those representations and warranties, again, they're going to tell the story about those risk issues. These now being those risk issues, the representations and warranties that will be made as of a certain point in time. Not necessarily things like covenants that are promises of things that will be done in the future, but as of a point in time, these are the representations that are being made regarding prior criminal complaints that Constand has provided to Cosby, names which are reflected in this article of all criminal law enforcement agencies to which she has reported any details surrounding the alleged incident. We want to control that risk by determining who already knows about it. So if you're going to make this representation then if there are people who pop up in the future who are not on this list, then that's going to be what? Yes. And regarding this agreement, a what? Okay. A section in this agreement. A termination event. And so then prior disclosures. See, these are coming straight from, again, go back up to my subject matter performance provision. You're going to find them right there. Risk. Controlling risk throughout the agreement. So this is going to include power attorneys. Now there's going to be major scuttlebutt about this in the settlement negotiations. They're going to be like, why and who? What? They're not going to want their names in there. But is this lady right here who handed over all that information to the district attorney, which is the reason why Cosby's in jail right now. You have to control that risk. And then, of course, Cosby's representation regarding payment of the settlement. And then termination provisions, which seems to cause the most consternation, but it's, I don't want to say it's simple. What I want to say is that you have to lay the proper foundation. If you don't have any risk or you don't have any client issues of concern outlined in your agreement, then it will be hard to find in your agreement. But you find termination events where in the agreement? For one. Of representation and warranties. Where else? Okay, but more globally. Could be, but any covenant in the agreement. For us, you see, for right now, I'm trying to get you to see so that you can see it. Put them, put them here. Later on, they may be somewhere else. But you need to be able to identify that it's a covenant and that it could be the basis of a termination event. Are there any questions so far? So for me, I'm going to start with my representations and warranties. This is my high dollar termination events are going to come from here. From those prior complaints. And then I'm gonna, after there, then I'm gonna start looking through here. Now, they are coming from that subject matter performance provision, but they're really coming from these business sections which are coming from here. So, for instance, it's a possibility that you know, let's say she fails to provide the withdrawal declarations. That could be a termination event. Someone will want to ask themselves, okay, do you want to terminate the contract, you know, because of that? Or these are things that you think about, but this is where you go to look for termination events. There's a lot of struggling about that, but they should be in your agreement already. Termination. In the event that Cosby discovers that prior to July 13, 2006, Constand has reported any details whatsoever surrounding the alleged event or any other matters regarding Cosby to the agents of any criminal law enforcement agency inside or outside the United States that are not set forth in Articles 4.011 through 4.014, or that any other representation of Constand set forth in Article 4.01 is untrue, Cosby may exercise the option of terminating the agreement, or he may forego termination and exercise remedies that are set forth in the remedies section. But you want to be clear, if you just allow for a blanket type of a termination situation, then you're going to end up on the other side of Stormy Daniels. You're going to end up on the other side of the Andrea Constand situation. You're going to end up Target sitting with a building 5 years on the corner of the street situation, because you did not provide a procedure for that eventuality. It is all well and fine to have your broad termination provision at the end after you have taken care of your risk issues, but if you don't control that risk in this agreement, you're the one that's going to be standing on the side of the road of the Target building. With the Target building. It is your job to control the risk. So you have to demonstrate an ability to cite those termination events and to be able to answer those 5 questions for each one of them. Because, let's see here, in that first one, on the date, let's see, or if Cosby exercises the option of terminating the agreement for this event, he shall provide notice, okay, and that notice is going to be pursuant to that notice provision. And then on the date of his receipt in full of that amount, this agreement will terminate. And then he may want to reserve the right to pursue other common law rights in the event that this termination event is not accomplished. Because if he does not receive the money, then he may have to sue the person, you know, or whatever the case may be. But the termination is a remedy, is a remedy in and of itself, inside of the contract to resolve an issue without having to pursue any type of common law rights, if that would be something that somebody wanted to pursue. But you would want to outline what provisions, if any, would remain in effect even after the agreement has terminated. And we certainly want that confidentiality agreement to remain in effect. These are the questions that need to be answered for each one of those termination events. So after after July 13, 2006, Constand has reported any details whatsoever surrounding the alleged event or other events. See, this is prior to. This is related to her representation and warranty. But now, this whole agreement is based on, in her business provisions, on her not making any further criminal complaints against Cosby. So to me, this is going to be more material in nature. I mean, this could land him in jail. So the termination provisions or procedures for this is probably going to be different than 6.0. But here, he shall have the right to terminate the agreement. Okay? See, that's going really straight to those business provisions. And then you'll see that there will be, I guess, an amount there in the remedies that would be payable for any damages that would be sustained by Cosby as a result of that happening. And then here's another termination event that goes to representations and warranties regarding prior disclosures to individuals. And so then the procedure here is set forth for that. And so then here it talks about covenants. Now, these are her promises regarding future disclosures. Okay? And this would include this is also going to include any disclosures to any law enforcement agency or any matters whatsoever regarding Cosby. And so then it gives you your termination event or your termination procedure for that. Initiation of future criminal proceedings, i.e., actually being the complaining victim in any case, then this is going to outline the procedure for that. That's going to be that's not going to be a situation that would allow for any, opportunity at that point other than to terminate the agreement. And then, what about failure to obtain the immunity order? For me, that's some more. I really want to get that if I can, but it's on the lower level. My main deal would be trying to make sure that there is no testimony provided by Cosby. But if I can get the immunity order, I want that immunity order. And so it might not be an issue where I would flat outright, go ahead and seek to, and terminate the agreement because of it. So I may want to provide some type of a, opportunity to continue on in that regard. So that's termination. And then the indemnities. Now, we're not going to do all of the sections. I'm just trying to hit the termination, indemnities, and then maybe the general provisions. But again, you ask yourself, where do you look to find these indemnity events? In the same place. to what provisions do we link our remedies? To the terminations. So there should not be this struggling, people in libraries for hours and hours on end. It's already in the agreement. Yes, ma'am.
Are you ever going to get a remedy that is not connected to a termination? Like, because I think...
Yeah, probably. I mean, I can't say no for that, definitely. But I certainly want to say you wouldn't be stuck. I mean, because you know where to find the major ones.
Okay, yeah.
And then with the ones that may not be there, then you're going to have a broad remedy provision.
Okay.
But I mean, it could be possible because, as I stated, it could be a default situation we talked about in the past, like somebody could die, somebody could file bankruptcy, and it's possible that there is some type of a remedy that might not link to a specific termination event. But anyway, this is where you go to find in the terminations. So for me, I want to completely control that risk. I know there are people who will think, what, are you crazy? Because for me, for Stormy Daniels, she would have defended and indemnified me if she had filed that lawsuit. That lawsuit that she filed, she would not need a judge to give me my attorney's fees back, because I would have an indemnification clause in here, and I would go up to the judge and I would say, she's in breach, and here's the amount right here. You can just go ahead and just sign the judgment right here so that I can get my money back. Because here, if Andrea Constand got off with my $3.4 million and she went and filed a lawsuit against me anywhere, she would be indemnifying me in that lawsuit. She would be paying I would be sitting right next to her. She'd be over there on this witness stand paying my fees. Because you have my $3.4 million. How can this be, what kind of equity is that? And so, it would be, there would be you would see it in the news. It would be a terrible kind of, because it would just be all over the news, thinking about how it is that, she's the victim and all this kind of thing. But you got my $3.4 million, lady. So I want to control that risk. And so in the event that she should initiate any future, because you promised that you would, in exchange for the $3.4 million. Then you will, or if Constand is the plaintiff in if she goes and files a civil lawsuit against me. For any of these reasons, she shall defend and indemnify. And then this provides the procedure for that. Here is a procedure also for indemnification by Cosby regarding payment of the So we'll come back to that when I get to that particular section. So then we have our remedies here, and those remedies are going to link straight to those termination events. So if Cosby elects to exercise the option of termination of the agreement for the 6.0 termination, then Constand shall pay $1 million payable by certified check per each prior criminal complaint that she failed to set forth in Article 4.01. Now, what you do is you negotiate these things. I'm sure if I'm negotiating with Stormy Daniels' attorney, she's not going to like the fact that I want to put that in the agreement. And so we're going to have a fight about that. But if you are negotiating with a person and their lawyer lets you put that $1 million in there and let their client sign the agreement, then, well, why is that my fault? But I want to control that risk. I want to say, Stormy, you better put everybody down here on this piece of paper who you told about this thing. And I bet you everybody who's told would be on there if, in fact, the remedy is $1 million per person that she didn't put on it. You have to control the risk. So this is, and it's nothing, it could be an old tired story that I'm reading to you here, because I've been talking about these same events since I came in. It is a focus on the client's issues of concern. I have identified them from start to finish. I had my little worksheet. They're on my worksheet in my negotiations. Then they end up in my words of agreement. Then they show up in my subject matter performance provision. Then they end up in my business provisions. Then I start talking about them again in the representations. Then that's the same ones in the terminations, the same ones in the indemnities and remedies. As the time goes on, as I start tweaking it and working with it, I'm like, oh, wait a minute, oh, no. And then I go back and I'm like, oh, yeah, I need to control that a little bit, because what if this happens? I'm starting to see it now as I'm going forward. And then I'm going to talk a little bit about the general provisions. For me, in this particular agreement, I may want disputes in this agreement to be handled by arbitration. In my other agreement, in my ski lift agreement, I wasn't really, I may needed to have to go into court to take care of some business on that if somebody didn't act right. So, but here, I want to be dealing in confidentiality more so. And so I may want to handle my disputes in arbitration here. That governing law in arbitration is still going to be, see here, it should not be California. It can be California. I left some options for California because Bill Cosby comes back and forth. He's everywhere. But it depends in this particular case. She's a Canadian resident, so it's hard to say. And then I'm definitely going to have that notice provision in there. I think I forgot to talk about this a little bit in that last class. For me, I do not like agreements that get amended. An amended agreement for me is a new agreement. Okay. I know the book talks about, you can amend. I don't amend agreements. We have negotiated this agreement, this is it. If the agreement needs to be amended, then that's going to be, for me, a termination event. And so then you will see that reflected in my termination events as well. And then all of the other. Are there any questions about this? Are there any questions? So I would encourage you to make sure that you have worked on your worksheet.